Hello, my name is Derek Burke, and I am a Senior Program Coordinator at the United States Energy Association. I work on the U.S. East Africa Geothermal Partnership. To give a brief background on USEA, we are a nonprofit membership association of public and private energy-related organizations, corporations, and government agencies. USEA represents the broad interests of the U.S. energy sector by increasing the understanding of energy issues, both domestically and internationally, through capacity building activities and events like this one. If you would like to learn more about USEA and our work, I welcome you to go to our website at www.usea.org. We would like to thank our members and partners for their support in the energy sector during this difficult time. Each of us have felt the effects of this global pandemic, and we continue to work together to recover and come together stronger in the end. Today's presentation is about the legal issues and challenges encountered in geothermal activities, especially in projects involving direct and/or cascade use of geothermal resources. The first part of the presentation will deal with the main legal aspects of geothermal projects, including ownership of the resource, access to land, licensing and contractual issues. The second part of the presentation will consist of a case study of Reykjanes Resource Park projects and legal aspects of that project. I'm happy to introduce our speakers today, Mr. Baldvin Haraldsson, founding partner of the Icelandic law firm BBA Fjeldco, and Antoine Lochet, counsel at BBA Fjeldco. We will begin with a presentation by each of our speakers and then move to a Q&A session. If you have any questions, please use the chat Q&A button below to submit them. I will be receiving them throughout the presentation, and we will ask the presenters to respond after they are finished. With that introduction, I would like to commence the second Geothermal Industrial Park webinar, Legal Aspects and Challenges of Industrial Parks. I now hand it over to Baldvin and Antoine.
So can you hear me?
Yes.
Excellent. So thank you, Derek, for your kind introduction and for having us on this webinar, which we think is a great initiative. So good morning and good afternoon, everyone, depending on where you are located. My name is Baldvin Björn Haraldsson of BBA Fjeldco, and I am located in Iceland. And today, myself and my colleague Antoine Lochet, who is located in France, will discuss some of the legal challenges in the research and development of geothermal reservoirs, both for electricity production as well as for direct use. We will also discuss particularly the legal challenges in creating geothermal resource parks and present a case study of the resource park in Reykjanes, Iceland. As a general overview, we will first discuss the importance of the regulatory framework being adequate in order to be able to harness any geothermal potential, and importantly, in order to attract private and public investment for these purposes. As you are fully aware of, any development of geothermal resources requires substantial funding, and the absence of the correct regulatory and institutional framework has been a real obstacle for the utilization of geothermal resources in many countries. So Antoine will start by discussing the challenges in the general legal framework, and I will then present the resource park in Reykjanes, Iceland. So Antoine, the floor is yours.
Antoine, you are still on mute.
Can you hear? Can you hear me now?
Yes.
Okay, so I will just resume. So good morning and good afternoon, everybody. So as Baldvin said, I'm going to say a few words about the legal aspects and legal challenges of geothermal industrial parks. Before addressing those issues, I would like to say a few words, or just to set the background and look at what constitutes a geothermal industrial park. So one way to look at those parks is to consider them as eco-industrial parks, which integrate exclusively or partly the use of geothermal energy. So as the United Nations Industrial Development Organization has defined eco-industrial parks, they are earmarked area for industrial use at a suitable site that ensures sustainability through the integration of social, economic, and environmental quality aspects into its siting, planning, operations, management, and decommissioning. So when we will look at those geothermal industrial parks, we will think of them as eco-parks that integrate various activities using geothermal energy to a greater or to a lesser extent. So usually at the core of a geothermal industrial park, there will be a plant generating electrical power and or heat. And that project will then feed the other businesses in power and or heat. And that's actually the legal relationship between those participants that we are going to study today. So just to give you a few indications as to which businesses, which participants we will find in the geothermal industrial park. As I said, there would be a power generation unit. We could find some greenhouses, some cooling facilities, fish farming, meat processing, or balneology. So those are a few business ideas that we can find in the Reykjanes Geothermal Park that Baldvin is going to introduce later. So connecting those businesses in the Geothermal Industrial Park raises various legal and regulatory issues. Most of those issues are common to all geothermal projects. That means that regardless of whether those projects are part of a geothermal industrial park or not, those issues will be relevant. But some of them are crucial and especially relevant to geothermal industrial parks. So here's a brief overview of those legal issues I'm going to address today. So we have the question of ownership of geothermal resources, question of access to land, licensing issues, cascade use issues, which are quite important in the case of geothermal industrial park, environmental issues, contractual issues, which are also highly relevant for our cases here. Questions of access to networks, corporate issues that are not directly energy or environmental law related, but are extremely important in the context of geothermal industrial parks. And then I will say a few words about foreign investments, as we will assume that in some circumstances, foreign investors will be involved in geothermal industrial parks. First, the ownership of the geothermal resources. In most jurisdictions, geothermal resources are in the ownership of the state or the people. That means that private ownership of the resource is not possible, and that access to the resource is granted through licensing or concessions. So in terms of legal techniques or technicalities, the principle of ownership is usually provided for either in the constitution of the relevant states or in a special act, either a Geothermal Resources Act or Energy Code, or at least most of the time in a piece of legislation enacted by the local parliament. So just to give you a few examples, although it is not a comprehensive list, but just a few examples of jurisdictions where we would find a state ownership or at least ownership by the people of resources, including geothermal resources. We have Turkey, Mexico, Chile, Italy, Ethiopia, Kenya. I would name France as well. And as I said earlier, this is maybe the most common structure of ownership of resource that we would find worldwide. But it's worth mentioning that in some jurisdiction, private ownership of the resource is at least technically possible. There are some jurisdictions where the general rule is that the owner of the surface also owns the resource beneath the surface. So we can find some examples of that in the US, maybe only in certain states. So it is there possible, but it is, as I understand, quite unusual because most of the geothermal resources would be located under state-owned lands. In Iceland, we have a similar approach, and Japan also has a similar approach. But the impact of those rules, as I just said, can be quite limited because most of the time geothermal resources would be located beneath state-owned lands. So basically the state, or at least a public entity, would be involved in investing ownership or granting rights on the resource. Well, the question of ownership is crucial when it comes to setting up geothermal industrial parks. Firstly, because it will dictate the involvement of the states or the public parties. It will also dictate the involvement of private landowners even when they are not involved in the project. But also, and most importantly, it will dictate the relationship between the business participating in the geothermal industrial park. Because each business will need to secure a right to access to the resource, and either by securing ownership, or well, the local legal system allows it, as I just explained, or by securing a right of use of the resource. And such right, for example, could be granted in the form of a steam supply agreement or a lease agreement. So if we take, just to be practical, if we take an example of a industrial park that would be structured around a geothermal power plant, if the power plant's owner is the owner of the resource, it could sell or transfer ownership or grant right of use on the hot water or on the steam produced. But if it is not the owner of the resource, the plant owner would have to secure rights of use first. So for example, through a steam supply agreement. And then the question would arise as to the regime of the remaining products. So the hot water or the cold water, which are generated by the power plant after having produced electricity. So either the plant owner will have to grant, or first be granted the right to grant further rights on the resource, or the other businesses in the park would have to apply for a permit from the local authority. So on the legal structure of the project, ownership is important, and that issue needs to be tackled, I would say, from the very beginning of the project. Another aspect is the issue of access to land. So first, the role of the landowner is quite obvious when the landowner owns the resource. Some kind of agreements need to be found with the landowner. Although we will see that there are some mechanisms that could help circumventing this lack of an agreement. But even if the landowner is not the owner of the resource, well, the license holder, so the party that holds the license to explore or harness the resource, would have to reach an agreement, at least to access the land, and would have to compensate the landowner as to well, for the damage incurred by for example, because of the building of the power production facilities or the exploration. Regarding access to land issues, we also have planning issues. So it is important to ensure that the land on which the park will be located that industrial facilities may be built on the plot of land. There is certainly, depending on the local legislation, there is certainly a master plan. So it would need to be ensured that the facilities can be built and is in line with the master plan, or if not, look into the changes that would have to be made and negotiated with the local authorities. And just to finish, just to come back on the role of the landowner. If the landowner is not willing to grant access to its property, most jurisdictions would provide for expropriation and/or compensation mechanism. Next point is licensing. So generally speaking, the question that arises quite quickly when a country wants to develop the use of geothermal energy is whether a specific regulatory framework should be put in place. So it is quite common, at least to begin with, that mining law is used as a frame of reference. But quickly it appears that mining laws might appear inappropriate to regulate geothermal projects. So for example, geothermal projects have a different business model. Mining and geothermal have in common the extraction of the resource, but geothermal is seen as a renewable energy, whereas extraction of minerals is not a renewable or sustainable activity. So we have two different kinds of projects, and which demands two different kinds of legal frameworks. And usually the timelines of mining projects are not the same as timelines of geothermal projects. So mining licenses might appear to be too short or too long and would not be appropriate for a geothermal project. That would apply in the case of geothermal industrial parks. So many countries that have decided to engage in the development of geothermal energy, they decided to adopt specific legal and regulatory framework for geothermal. Just to give a few examples, there are specific geothermal acts in the US, in Kenya, in Ethiopia. I should name also Mexico and Indonesia. There are some countries that still rely on mining code, but would certainly include specific provisions on geothermal energy and geothermal activity. I would name, for example, the French mining code, which includes chapters on geothermal energy, but the licensing framework more or less follows the mining law framework. So there are several types of license allocation methods. So there is the direct approach. That means that the private entity leading the park project would directly approach the authorities. But we also have a tender approach. That means that competition, where there is competition between candidates, and there is a tendering process. And most countries would basically have a mixed or hybrid system, while allowing some direct approach, but relying mainly on a tender approach. And just to name the types of licenses, there is nothing new here. I should note that usually legal systems provide for exploration licenses and exploitation or operating licenses. What's important in our study here is to look into the activities, the geothermal activities that are licensed under the local law in the local jurisdiction. So first, of course, exploration, but leaving exploration apart, we need also to ensure that the local legislation does not exclusively focus on power generation or heat generation. There is a need for a license, well, different types of license activities, and especially direct use, because geothermal industrial parks are all about direct use. So some of the businesses would use the resource directly, not to transform it, but just to use it as it is. And it is important that the legal system and the regulatory frameworks allows that type of activity. A word also on mineral extraction, because I just talked about mining law, and you are probably aware that some minerals can be extracted from the brine or from the geothermal fluid, and actually that extraction makes some geothermal projects commercially viable. So they are extremely important, and it is very important that the local framework provides for clear rules on mineral extraction. And for example, it could make sense, depending on the local laws, to refer to the mining code just for the mineral extraction part of the activity. But here it is also crucial that local laws address the mineral extraction, the mining aspects of geothermal activity. Well, regarding the criteria for issuing the license, well, those would be similar to what we would find in other fields. For example, in mining law, usually they would rely on experience, financial strength or financial aspects, and eligibility in terms of ethics, for example. So I'm not going to expand too much on that. Usually, licensing, what we expect to find in the license, well, provisions on the duration of the license, conditions of termination, conditions of renewal, whether it contains or provides for a right of priority or not. So if the holder of an exploration license, for example, can bring evidence of resource and of a commercially viable resource, then the holder of that license would like to be granted a right of priority to obtain an operating license or a harnessing license. So it is also very important that the local framework allows that type of right of priority. Decommissioning is also crucial, because eco parks and geothermal parks, well, bring a lot or pay a lot of attention to the whole cycle of the project from beginning to the end, and decommissioning is part of also is part of the whole process. So the license would definitely have to provide for clear rules on decommissioning. As I said earlier, CASCADE use is at the center of geothermal industrial parks. It is actually the very essence of that kind of project, to allow for a multiple use of the resource, either as a chain of use. So one operator, for example, the power plant, using the resource, and then transferring or allowing access to the resource to another operator that would, for example, need geothermal fluids or hot water of a lesser temperature. So it is important that the legal framework and also the contractual framework allow for that chain of use of the resource. And because we are here looking at a shared resource, legally speaking, we are thinking and wondering about the shared liability. So if we share a resource, do the operators also share the liability? For example, in case of damage caused to third parties. And also in the relationship between the operators, so between the participants, there's also the question of the chain of liability. So if the water or if the fluid is not of the expected quality, who would bear the responsibility? So for instance, if we have a power plant that would then provide hot water to a district heating network and that would provide cooled water to a sea farm, if the water provided to the sea farm is of a poor quality, could the sea farm owner have a claim against the district heating network or district heating company, or could also it have a claim against the power plant? So because we have here a chain of contracts, the question is really if we can contractually provide clear rules on the chain of liability of all the market participants. So moving to the next legal issues. So the next category of legal issues would be environmental and social issues. So of course, that type of infrastructure, talking about power plants or heat distribution networks or fish farm factories, they have impacts on the environment, and the question is what the local jurisdictions provide for in terms of legal framework for environmental impact. So it will have to be looked into, for example, whether a global impact environmental impact assessment is necessary for the whole project or for each individual project, so each individual business in the park. Also, because to a certain extent, the geothermal park relies on transfer of wastes, if I may say in quotation marks, between the participants. So basically, the hot water generated after the production of electricity by the power plant can be seen as a waste that is then allocated or transferred to participants of the geothermal park. The question of how this fits into the waste management regulatory framework, that is something that will be addressed. So here, moving on to issues that are less related to energy law or environmental law, and that would be like maybe common law or common business law, but are actually very important in the context of geothermal industrial park. Those are the contractual issues, because those market participants are going to be connected to each other by contracts, and therefore those contracts have to address certain legal issues. So, for example, well, first on the types of agreements that we would see or expect to see on geothermal industrial parks, we would have power purchase agreements, so so-called PPAs. Those PPAs, they could bind the power plant or the power producing company to the market participants if this is allowed under the local jurisdiction law, but maybe the other structure would be for the electricity to be sold to the network or to the grid, for it to be sold to the market participants. So we have here a regulatory issue as to how electricity can be sold to the market participants. Another type of agreements would be the steam supply agreement or heat supply agreement. If we have a carbon recycling facility in the geothermal park, we would have carbon supply agreements. All the laws relating to public-private partnerships and concessions would be applicable as long as the state or a municipality is involved, and we would expect that it would be the case in most circumstances. And then a chain of supply and purchase agreements between all market participants, mainly dealing with hot water or supply of cooled water or cooled air in case of cooling activities. So those contracts, regardless of what they cover, they would at least need to contain, to our opinion, provisions on risk allocation. I talked earlier about sharing responsibility. So risk allocation in terms of quality of fluid, damage to the environment, damage to third parties, force majeure, resource risk, all those risks should be allocated carefully in the contractual structure of the park. Part of the risk allocation is allocation of financing. Who finances the infrastructure? We have questions on security of supply. So basically take or pay provisions on electricity or hot water. And then there's the question of pricing. Is it relevant to think, for example, about an indexation on price of energy for all business relationship within the park? Just a few words on access to networks. I already mentioned local grids. So the attention would need to be paid to the regulatory framework here. Does the power plant, is it allowed to connect directly to the market participants, or does it need to connect to the local or the national grid? And the same would apply to heating networks. And then, just to finish, the corporate issues are also very important. Here, and I think I will finish with that, we need to look at the global picture, because the geothermal park is a project involving many participants that can have different interests to protect. But they are all looking into creating synergies and collaborating at least around that common resource, which is the geothermal resource. So very importantly, a question must be asked as to what is the best vehicle, what is the best structure for those interests to be represented and to be protected. So that would actually depend on the local laws. So there's no clear-cut answer, but the solution can be found in the local law of associations, the local law of corporations, partnerships. In Europe, we have the economic interest grouping, which is a question whether it is available in East African countries. But at least it is crucial that project is structured in a separate entity or in a group of entities for government issues and also for monitoring issues. Well, I'm going to hand over to the microphone to Baldvin because I think I'm running out of time. I will maybe address finally the foreign investment issue when we wrap up the presentation. So thank you for your attention, and Baldvin, the floor is yours.
Thank you, Antoine. So am I sharing the right screen now?
We see your desktop. We're not seeing your presentation.
Okay. Here we go. Let's see if I have that correct now.
Yes.
Okay. Excellent. So I hope you can see the slide now.
Yes.
So I will now give you a short overview of the resource park in Reykjanes, Iceland, and discuss some of the legal challenges of setting up and operating such parks. But Antoine has discussed that to a certain extent earlier. So the resource park has been developed in the neighborhood of 2 geothermal plants in the southwest of Iceland, less than 1 hour's drive from the capital, Reykjavik. It is a good example of the possibilities of increased and more efficient utilization of geothermal reservoirs. Each company in the resource park uses byproducts from the geothermal plants in their operations. As a result, it's important for these companies to be located near the power plants. The object of the park is to foster what they call a society without waste, meaning that all resources flowing to and from companies are utilized in full, responsibly, and for the benefit and progress of the community around it. Each company in the park uses 2 or more resources from the geothermal plants through agreement with HS ORKA, the owner of the plants. Here you can see an overview of the part of the resource park, which is in Svartsengi, where the Blue Lagoon is located. As you can see from this overview, the Blue Lagoon operates a general spa, the health spa, and the new 5-star hotel called The Retreat, and its research and development center. You will also find the Northern Light Inn Hotel, Carbon Recycling International, and a company called Orf Genetics. I will discuss the nature of these companies in the next slides. It's also important to note that one future potential activity is the power to gas venture. The oxygen from such production could be used by companies within the resource park engaged in fish farming. Now, here you can see the companies located in the Reykjanes section of the resource park, being Stolt Sea Farm to the left, as well as Haustak and Laugafiskur, bottom right. They are engaged in fish drying. Now, the prospective operations there are not meant to be a declaration of intent of any nature by these companies, but are just considerations of what can be possible in general in the operation of resource parks. You have the production of precipitated silica. Blue Lagoon uses silica by mixing with dioxide, for example, creating the silicon dioxide used for skincare. Silica is from the earth crust and includes various ingredients necessary for bones, skin, nails, and teeth. And Geosilica is another company in Iceland using silica into daily supplements in drinks with nutrients. Now we have the algae production, which can be produced for fish consumption and human consumption. Furthermore, you can see Cotland here in blue on the lower right, where the intention is to have production of mineral supplements, fish oil, and orally administered collagen-1 peptides for human consumption. Then also vertical farming in the middle of the page, which I will discuss later on. And here is a short video of the resource park, and I hope you will be able to see this video here. Here we are. I trust you see it.
Yes, we see it.
Okay, so this is just a sort of a good video which shows some of the activities in the park. You can see the connection between these two power plants and the companies operating in the park. So here, so I hope you got a good look at that video, which is sort of a good overview of the companies there. Here you can see a flow chart of the resource park. To the left, you will see the Reykjanes power plant provides for fish drying, fish farming, and the earth exhibition of the power plants, whereas the Svartsengi power plant to the right provides for the production of methanol, molecular farming, and the Blue Lagoon. As an example, you can see on the top right the production of methanol. That production requires steam, which is the green line there, CO2, the blue one, and cold water, the light blue, electricity, and hot water for its production. So this is a good overview of the flow chart within the park. Now, the impact of the resource park on the municipalities in the Reykjanes area is substantial. You can see that it creates a number of jobs, which has only increased since 2018. And these jobs require a high level of education, and these are actually well-paid jobs. Now, on the legal challenges, Antoine has already discussed many of the legal challenges in development of geothermal resources and the setting up of power plants. Now, the legal challenges relating to other companies within the resource park mainly, as Antoine said, relate to the direct use of geothermal resources. Attention needs to be given to the structure of the resource park in question. In the case of the Reykjanes Resource Park, the companies located there are held by different stakeholders, and they cooperate through bilateral agreements with HS ORKA, the holder and operator of the power plants. This means that any shortage of material resulting from natural causes, as well as from maintenance matters, can directly affect the operations of the companies within the park. It is, however, important that the risks of power outages or maintenance of HS ORKA itself relating to the delivery of electricity are basically not existing as the companies acquire their electricity from the grid. Now, the bilateral agreements between each company and the power plants need to take into account all these potential disruptions. And such agreements need to provide for sufficient warranty provisions relating to the material being provided. Now, all the companies have zoning requirements to deal with, and some of them are also subject to environmental assessments. Now here, HS ORKA is the owner of the 2 geothermal power plants within the resource park, and is the largest privately held power generator in Iceland, with over 174 megawatts of production capacity from geothermal resources, which is sold on to the grid. 2 companies, municipalities and homes in the southwest coast, and 2 companies within the resource park. The company produces also hot water and harnesses fresh water, which is sold to a local distribution network. The legal challenges in respect of the setting up of power plants have been discussed by Antoine. This company has an operation license and a generation license and a utilization license for the reservoir, which is applicable for 65 years according to Icelandic laws. Furthermore, the company has a land lease agreement for the ground under its operations with the Icelandic state. It is also important to mention that all geothermal energy prospects in Iceland are evaluated by the Icelandic state and need to be inserted in the so-called master plan, the plan of the Icelandic government with respect to energy prospects. So these prospects they can be put in preservation category, they can be put in a waiting category or a utilization category. The Icelandic Parliament reviews this master plan every 4 years. So one of the legal challenges of HS ORKA in general is to make sure that their energy prospects are accepted into a utilization category. In Iceland, all geothermal power stations and other thermal power installations with a heat output of 50 megawatts or over, or an electricity output of 10 megawatts or over, are subject to an environmental impact assessment. HS ORKA is therefore subject to such assessments in its operations. Now, the main regulatory concerns of HS ORKA within the resource park is to correctly negotiate with the companies in the handing over of these byproducts. Here you can see HS Veitur, and this company is acquiring hot and cold water from HS ORKA and distributing to the nearby communities, and distributes directly the hot water for heating of houses through bilateral agreements with HS ORKA. And the main legal challenges here are the taking of risk or allocation of risk when the hot water is delivered. Here you probably all heard of the Blue Lagoon. As you can see, the Blue Lagoon has various operations and produces, for example, skincare products, has the retreat spa, the restaurants, the hotels, the travel services, and the psoriasis clinic and their research and development center. The excess brine from the Svartsengi power plant is what makes the Blue Lagoon possible. And here again, one of the main risks obviously relate to environmental aspects and the taking of risk, the allocation of risk when accepting the water from the power plant. And so the Blue Lagoon receives hot water, cold water, geothermal seawater, electricity, steam, and carbon dioxide. The companies Haugstag and Laugafiskur are engaged in the drying of fish or the parts of fish which was previously thrown away. This company receives electricity as well as hot and cold water from the power plants, and the products are primarily sold to Nigeria, where they can be stored outside for up to 2 years without need for cooling. ORK Genetics is a pioneer in the manufacturing of growth factors and recombinant proteins in plants, and the company produces skin care products distributed to many countries and receives hot and cold water and electricity from the power plant. And future possibilities of this company relate to enhancing of the growth factors, but obviously that is only a speculation, but a possibility within this sector. This is Carbon Recycling International, which produces renewable methanol from carbon dioxide, hydrogen, and electricity. This is a product used in fuel applications and the efficiency enhancement. Natural carbon dioxide from the power plant is used as raw material in the operations of this company. You can see here the Stolt Sea Farm, which engages in fish farming of tropical fish from the clean seawater. The water has been filtered through the lava layers, resulting in a pure, lukewarm seawater. The company requires less electricity through the use of this lukewarm water. Now, Matorka is another company within the park that farms Arctic char and steelhead fish without any need of antibiotics, chemicals, or hormones. The fish is hatched in pure glacial water and is therefore free of parasites and pathogens. Now, future possibilities relating to algae production and oxygen from fish production are, of course, only speculations of what can be done. Finally, just a couple of words on future food security and the potential of resource parks in that area. Algae is expected to play a key role in the food security and diversity in the coming years as a sustainable alternative to current food sources. The resource park is ideal for algae production with abundance of renewable energy, fresh water, and natural carbon dioxide. And finally, the land-based agriculture or vertical farming will also be important as a source of high-quality food, free from pollutants such as mercury or microplastics, and without adding the strain on the oceans in the form of overfishing. Vertical farming can actually result in 95% less water used for the production, as well as 4 to 6 times more crops per square feet. On these sort of last slides are just the possibilities that can be what one can see within these resource parks. So this was a brief overview of the resource parks. Antoine, perhaps just to sum very, very quickly up the main legal challenges, just for a minute or two.
Yeah, yes. Can you hear me?
Yes.
Okay. So just to summarize and wrap up the presentation, sorry, we lost the PowerPoint, but it doesn't matter. So just to summarize, really the legal challenges that we have identified for, well, in relation to geothermal parks. The ownership and access to the resource is crucial. We have to look at regulatory issues, so issues such as licensing, environmental and social impact issues. Make sure that all the activities that will be present in the geothermal parks are allowed or can be licensed under the local laws. Issues relating to the access to land. Contractual issues, so very importantly, the allocation of risk and the allocation of responsibility and the question of shared responsibility. And finally, the question of access to networks and whether local grids can be built and whether off-grid connections are also possible. Just a few words to finish on foreign investments, because I didn't have the time to address that issue, but we can expect or assume that some foreign investors would be willing to invest in whole or part of the activities of a geothermal industrial park. So it is very important that the local laws allow for foreigners or foreign entities to invest in such projects. So, for example, in case of power production, does the local law allow independent power producers, for example? So that's really a crucial issue to look into. Well, on the contractual side, those foreign investors, they will ask for arbitration clauses and they will ask for change of law clauses. So that's also something that needs to be looked into. So from a global perspective. Well, that's it for the legal challenges. I would like to thank you all for your attention, and we are now all ears for any potential questions you may ask.
All right, thank you very much, Antoine and Baldvin. That was really interesting presentation. You covered a lot of information there. As Antoine said, the Q&A box is open in the bottom corner. We'll be taking your questions now. And if you are watching this later on YouTube, you can send your questions to me at dburke@usea.org, and I will try to get those to Antoine and Baldvin to give you at least some sort of answer. I know we have a lot of people that watched after the actual event, but we do have 2 questions that came in while you were talking. The first one is, does a company need to have a generation license in order to operate a geothermal industrial park?
Well, just perhaps a couple of points on that. I mean, generally, when you have such a park, it includes a power plant which the other companies within the park can connect to. So that power plant would generally need a generation license in order to be able to generate electricity, which is would generally be foreseen as a prerequisite for such parks. But also, as I discussed earlier, a generation license is one thing. And for example, in Iceland, I mean, the legislation is different between countries, but in Iceland, you also need a utilization license in order to be able to utilize or access the resource itself. So that there is an operation license which can come from environmental administration or public authorities, environmental, and then there is a generation license and a utilization license. But that, as I said, varies a little bit between countries.
Okay, great, thank you. So we have a second question here. Is the transition from exploration to exploitation licenses highly jurisdictionally dependent, or are there any general international standards in this regard? I know geothermal industrial parks are pretty new, and the most successful ones are in Iceland, but is there any international standards that govern things like this or geothermal?
Antoine, you want to take this one?
I'm not aware of any international laws that would apply to geothermal activities. So the transition from exploration to exploitation, that actually would depend on the local laws, I would say. But it's interesting that when we compare legislations, we can see some trends into those transitions. So, for example, the right of priority I was talking about, this is something that we would find in many jurisdictions. So the priority that the holder of an exploration license has to then proceed with exploitation activities. Well, this is something that we find in general mining law, and that we would find in many geothermal local laws. Then there are some best practices, of course, but that are more business practices and based on technical aspects more than legal aspects. But yes, that's hopefully helpful. Yes,
I agree with that, and we have prepared in cooperation with many law firms in various countries an overview of the existing legislation in geothermal, which is called the Geothermal Transparency Guide, and I think we have 17 countries involved to date, and that database can be found on our website now, and this has also brought to light the fact that there are different rules applying in countries, and there's perhaps a need for a comprehensive sort of guide or sort of a set of rules for countries to have in order to sort of adapt this legislation and make it more coherent between countries.
Great, thank you. I think I'll ask one final question. It's related to what you were just saying about the international standards and adapting it to the different countries. We have many policymakers that watch these and that we work with on a daily or in our work. And so they're just getting started on their journey towards the geothermal industrial parks. I know this is very kind of trying to summarize your whole presentation into one thing, but can you give maybe the 3 highest level priorities that they should be looking at when they start to set their policies that could address some of these legal issues that they have? If you could just give us the top 3, and that would be great. Thank you.
Yeah, that's a really important question. I think one thing. I mean, Antoine discussed this, and Antoine, you maybe have a word on this, but one thing that springs to mind is the ownership of geothermal resources, which is different between countries. And in general, perhaps the second thing is the institutional part of it, because one of the problems that we see, and this is obviously different between countries, and it's difficult to have one set of rules on the institutional aspect of this. But one of the problems which investors and developers have when they are approaching a certain country to harness the geothermal reservoirs is the institutional part of the regulatory framework, because it is very important that there is a single party within the administration which is responsible for interacting with the developers and the investors, and perhaps that is another aspect of it, which obviously, as I said, is difficult to adapt between countries, but it's very important. Antoine, what do you think about the third one?
Yes, I have a third one, and that's the question of direct use and cascade use. So that's highly connected with the question of ownership, but really it should be ensured that the law is clear on other uses than electricity production and heat production, because we have various activities that do not fit into one of those categories, and when it comes to licensing, it can be quite challenging. So really importantly, yes, covering direct and cascade use in legislation.
Yeah, and perhaps the main reason why we engaged in the data center, which is the Geothermal Transparency Guide, is and the reason why it's called the Transparency Guide is the fact that there is sometimes little transparency in what rules are actually applicable in countries when it comes to the research and development of geothermal resources, because the provisions which apply to this research and to the development of these resources are to be found in many different codes in the law. And so it is absolutely critical that countries have a certain code which can be relied on. Although it is necessary to refer to other codes in respect of, for example, environmental aspects and zoning aspects, it is important to have a code which can be relied on by the developers and, for example, by foreign investors.
Great, thank you. I know that was kind of a tough question to end on, but I just think it's really important for our East African partners to, as they're going through this, thinking about it. I know both Kenya and Ethiopia are very interested in this, and they're moving farther down the road. I just want to make sure that we can help them get the information they need. So I'm going to wrap up now. I want to thank Antoine and Baldvin for being a part of this and sharing their knowledge with us. We really appreciate it. So thank you for joining our second webinar in our Geothermal Industrial Parks in East Africa series. I hope you enjoyed learning about this very important topic, and I would like to thank our wonderful speakers again today for sharing their time and their knowledge with us. Please be on the lookout for the registration for the next webinar in this series coming in October that will focus on the types of tenants who can most benefit from geothermal industrial parks. And additionally, if you look at the slide that we're sharing right now, we will have another geothermal webinar series that's focused on innovation in geothermal energy production. And the first webinar in that series will be on September 26th, and that will include a presentation by Mr. Kevin Kitts. You can see a brief description of the webinar on the slide presented right now. And if you are not already on our mailing list, please send me an email at dburke@usea.org, and I will put you on that so that you will receive all the updates about the EAGP activities and webinars that are upcoming. Again, thank you, Baldvin and Antoine, for sharing your time, and I will see you guys next time. Thank you.
Thank you, Derek. It's been a pleasure.
All right.
Thank you.